I'm so glad you could come back. My name is Kimmy Cummings, and I'm going to be dragging you through this bar prep. We're going to start off first with property. And for these videos, I am going to be the evil mistress of property for you. So first, we're going to talk about ownership of real property. Because in order for that property to be used, you have to own it. So who are the important people when it comes to ownership of property? Well, we have a grantor, who is the owner, current owner, or the seller, donor. Now, and then we have the grantee, who's the buyer or the recipient of that property. The way we're going to do this is I'm going to help you with some mnemonics. And if you don't know what a mnemonic is, well, you might have bigger problems. Now we're going to move on to special problems. Don't we just love our special problems? Don't they just bring us joy? Let's start with the rule against perpetuities, or rap. And I'm not talking about rap music. Some of it can be decent, but we're not talking about rap music. You might be wondering, well, Kimmy, when can I rap? What does rap apply to? Well, rap applies to the core. It's important to work on your core. So, rapping is core. So what does that mean? Well, it means contingent, options to purchase retained in a deed, remainder interests that either follow a live estate or follow some event, and executory interests. Do you remember all those from earlier? If not, you can go back, okay? I'll wait. So again, rap applies to core future interests. So you're probably wondering, well, Kimmy, what happens if there's been a violation in my perpetuities? I've violated rap. I've just violated it. Well, the nice thing, if you've violated rap, all you need is some furs. Fur, to be exact, cures perpetuity violations. No. Put the skinning knife down. Not that kind of fur. You crazy. Certifiable. FERS means administration of the estate contingency. Fertile octogenarian exception, unborn widow exception, reducing an age contingency to 21 years, or the perpetuities savings clause. Now, for all you lovely MPEs, it can also be a saw fur. And that does not mean I want you to go grab your grandpa's saw and see if there's fur attached to it. That's not the case. It adds wait and see doctrine That's how you get a sulfur. You wait and see. Administration, fertile, unborn widow exception, reducing an aging contingency, and the perpetuities savings clause. There's quite a few people. Quite a few. By quite a few, I mean almost everybody. Almost everybody hates rap. Quite a few people love the music, but almost everybody hates rap when it comes to property. Now, rap doesn't apply to future interests that are part of the C2 group. C2 group. Now, that's covenants running with the land, which we'll get to. You'll learn all about your pints and your cans and, when we get to covenants. A remainder interest passing from one charity to another charity. So charity to charity. Get you, an exemption from rap. A revisionary interest retained by the grantor. So, possibility of reverter, right of entry, or a reversionary interest on a long-term lease. A tenant's option to buy or to renew contained in a long-term lease. A future interest in a trust benefiting the U.S. government. Yeah, you know the U.S. government's not going to let, little old thing like rap hold them back. No. Now, the last one, preemptive rights of first refusal to buy. Now, in New York likes to be a little special. Can't blame them. They're New York. New York. Only first refusals of a commercial nature or involving government rights are exempt from rap. And those are the only things that can fall outside of the rap period. Again, that's your C2 group. C2 group. Covenants running with the land from one charity to another charity. Revisionary. Option to buy. Future interests benefiting the U.S. government. Or preemptive rights of first refusal to buy. Now, remember I said we would discuss Shelley's rule earlier? Well, Shelley's rule applies, it's a special problem, that applies to landlord-tenant cases. Say your landlord has allowed an assignment. Shelley's rule means that they have allowed all assignments going forward. So if they allow it once, through either agreement or action, all future assignments are on the table. Now, the original tenant is always going to be liable unless they get a separate document. Separate. That is called a novation, which is only landlord-tenant. That's the only way they're stripped of all liability. Otherwise, they're still liable if, the person they assign or the person they assign skips out on the rent. So that's important. Now, we're going to talk about the Fair Housing Act. This will come up quite a lot when it comes to, well, owning a real property. Oh no, you mean we gotta be fair? Well, yes. You have to be fair. Now, we have protected classes. Those include race, color, religion, national origin, sex, disability, and familial status. Now, some of the prohibited practices that you cannot do based on any of these things. You can't refuse to rent or sell housing. You can't make housing unavailable to them. You can't provide different housing services or facilities. You can't make different terms for sale or rental of a dwelling. You can't falsely say there's no housing available. You can't refuse to make a mortgage loan or imposing different terms or conditions on that loan. You can't refuse to allow a disabled tenant to make reasonable modifications to the dwelling or common use areas at his own or her own expense. Now, refusing to make reasonable accommodations in rules, policies, practices, or services, if necessary, for the disabled person to use the housing is also not allowed. Prime example, no pet policies are unenforceable if the disabled person requires assistance animals or service animals. You may not threaten, coerce, intimidate, or interfere with anyone exercising a fair housing right. Now, you also may not advertise or make any statement that indicates a limitation or preference based on protected characteristics. That means some of your dating profiles would fail. Just take a moment and think that over. Your dating profile would fail if it was a housing advertisement. You could be sued. There is an exemption for owner-occupied buildings with no more than 4 living units, including the owner's living unit. Now, single-family housing sold or rented without the use of a broker do not generally apply to the advertising restriction. Your freedom of religion comes in here a little bit, because a religious community whose membership is not restricted based upon race, color, or national origin may restrict the sale, rental, or occupancy of dwellings that it owns or operates for non-commercial purpose to persons of the same religion, or may give a preference to those people. Similarly, a private club may restrict the rental or occupancy of dwellings that it owns or operates for a non-commercial purpose to club members, or may give preference to those persons. What do you do if you see a violation? Well, enforcement and compliance is done through HUD. The U.S. Department of Housing and Urban Development. It plays the lead role in administering the Fair Housing Act. Now, the available relief includes actual damages, and this does include humiliation and pain and suffering. Injunctive or other actionable relief, such as making a housing actually available. And the part that's important for, future attorneys, reasonable attorney fees and costs. Now, if the case is resolved by an administrative hearing, then a civil penalty to vindicate the public interest may be assessed. The federal court may also award punitive damages to teach you a lesson. Now, we're going to step a little further and talk about the proof of discrimination. Now, racial discrimination. The plaintiff need only show a disparate racial impact, not a racial intent or purpose, which is different than constitutional discrimination. So if they can show a disparate racial impact, they have established racial discrimination for the Fair Housing Act.